All right. Good morning and welcome to the October case call in this historic courtroom where our Michigan Supreme Court met from 1879 to 1970. Thank you to Senator Sarah Anthony for allowing us to robe in her office, and Senator Anthony's Chief of Staff, Janita Moore, and Senate Appropriations Clerk Scott Jones for all of their assistance. I also want to thank Rob Blackshaw, the Facilities Manager of the Capitol, for the invitation to begin our term here in this courtroom, and the attorneys representing the parties in this morning's case. The court has a great tradition of returning here for the first session of each term. Because of construction at the Capitol and then COVID, this is the first time the court has returned to this courtroom since October of 2017. I joined the court a month and a half later, so I have never sat on this bench, nor have three of my colleagues, Justice Kavanaugh, Justice Welch, and Justice Bolden. The court is excited to begin our new term, and with that, I will call our first case, People of the State of Michigan versus Duff. This is a mini oral argument on the application, and each side will have 15 minutes of argument, and you may begin when you're ready. And I want to note that we have a different setup here, so we know that you understand that you can sit or stand, and you have 2 minutes of a free fire zone.
Thank you. Good morning, everybody. My name is Issa Dad. I'm the attorney for Mr. Matthew Duff, the original defendant in this case. I'll plan to reserve about 5 minutes for rebuttal. It is my pleasure to be here today to advocate on behalf of Mr. Duff. This case is an important case to all citizens of this state. This case is even more important to Mr. Duff. Today we gather here to deliberate a crucial matter, one that goes to the very heart of our Constitution and our cherished rights as citizens of this great nation. We're here to discuss the actions of law enforcement officers who, in the name of justice, use their police vehicle to blockade the defendant's car in a parking lot. We must remember that justice cannot be served by infringing upon the rights enriched by the Fourth Amendment of our Constitution. The Fourth Amendment, as you know, protects all of us from unreasonable searches and seizures by the government. It guarantees that we as individuals have the right to be secure in our persons, houses, papers, and effects against unreasonable searches and seizures. This amendment is a bedrock principle of our democracy, and one that's apart from our nations where government intrusions in the lives of citizens in a commonplace. Now, let us consider the events in question. The police officers in this case chose to use their police vehicle to blockade the defendant's car, effectively restricting his movement and creating a sense of confinement. No reasonable person would feel free to leave. This question we must ask ourselves is whether this action was reasonable under the circumstances that respect the defendant's Fourth Amendment rights. The answer is no. It is anticipated that the prosecution will argue that no seizure took place, but let's break it down. They parked behind him. They shined their overpowerful spotlight on Duff's parked vehicle. Both officers were carrying guns with them. Both officers were wearing their full police regalia. Both officers exited their vehicles, taking flanking positions against the defendant. This is all before anything was ever said or any reasonable suspicion could have been generated, because this was a criminal investigation and a seizure has begun. Sixth, they pursued this investigation as a criminal investigation, not as a community caretaker function. This case.
First of all, thank you for being here today in this sort of flexible environment. We appreciate it, both of you. I'm wondering, what do we do with the abundant list of federal cases that might disagree with your position? How do we handle that?
The different circuits are different all over the country. The different circuits. The cases that I've reviewed, in the Sixth Circuit, U.S. versus C, all show the proposition that the Fourth Amendment, is infringed upon when the officers, restrict your movement. Now, it's my belief that People v. Anthony was decided wrongly because of the fact that any restriction by the government is a seizure, coupled with what their intentions are and what they're trying to do. And I'm hoping that we can start with this case and put some, make the Fourth Amendment as strong as it was, back in the day before it's been gutted. The facts of the matter is the Fourth Amendment is to protect us from unreasonable searches and seizures and from the government. And in this case specifically, there was a seizure as soon as they parked behind them. And if we take it to the next step, the spotlights, everything in this case, the facts of this case, the totality shows that there was a seizure before they even questioned my client, Mr. Duff.
Okay. Are you done?
Yes, please.
I hope I
You
answered your
started,
question.
you started out by saying there was a blockade. It was a partial blockage. You agree with that, right? Anthony, if it was a blockade under Anthony, it would be a seizure, correct?
Correct.
And Anthony may well have gone too far in saying that only if there's a total blockage do you get a seizure. So I'm with you there. I understand that. But once you have only a partial block, what do we look at? We're looking at the totality of the circumstances, correct?
Correct.
All right, so you've identified a few things. They put a spotlight. What was dark? What were they going to do? They were carrying guns. That's what police officers do. Does that create coercion? Police do investigate. They were in their uniforms. I'm not surprised. Did they make any verbal commands telling them not to move?
Not on the record. No, there's no evidentiary record of that. What it does state is the first thing they asked them was license, registration, insurance, which is part of a seizure, a Terry stop. In that case,
Well, those are two different things, aren't they?
I'm sorry.
Aren't they two different things? A Terry stop is something less than a seizure.
Well,
I mean, were the police, under your understanding, permitted to go in and investigate why a car at night is in a school parking lot?
yes.
Okay.
The
So the problem is when they pulled and partially blocked behind them, they should have pulled up next to them?
That would have been that wouldn't have triggered the Fourth Amendment right away. If they would have parked next to him, it would have been a little bit different. But in People v. Anthony,
But you agree, look, I'm giving you that Anthony and the only if officers completely block is probably overbroad. I'm with you on that. Now we're looking at the totality of the circumstances, and I'm trying to understand what raises a police officer's duty to investigate when they see something like this into a seizure. What have they done to get it to that level? And I'm not convinced, frankly, I'm being honest with you, when you tell me they were carrying guns. All police carry guns. If they were in a uniform, they all carry uniforms. I'm not convinced that they put light into the area they were going to look and investigate. I'm not convinced that they went up on each side of the car. That's for officer safety. This is what they typically do. I don't see why this rises to the level of coercion. This is a routine thing that people can expect anytime that they have police approach to do an investigatory stop.
and the test is, would a reasonable person feel free to leave and disengage? And for Mr. Duff to feel free to leave and disengage, he would have to try to back straight out. He couldn't do that. So that would have been a seizure. There's an officer on each side. If he were try to maneuver his way out, he'd be committing suicide, because the officer said in his intent he would have stopped him. He would have put his overhead lights on and his sirens. There was no escape for Mr. Duff to feel free to leave. Therefore, it constitutes a seizure. And all this happened before they opened up their mouth and asked for license, registration, and insurance. So totality of the circumstances, this was not a casual encounter. This was a seizure.
So what should the officers have done here, in your view?
Well, in my view, they wanted to go and investigate. And, they could have not parked behind them, number one, okay? Number two, maybe go to the same side of the vehicle.
So let's just start with, they have a right to investigate wherever they see a car running in an elementary school parking lot at 10 p.m. They have a right to investigate further. You would agree with that?
Yes.
Okay. So how should they have proceeded?
Well, to investigate, they could have called and see if there's any reports of any crimes in the area. They didn't do that. They could have pulled up to the side of them. They, could ask if there, find out if there's any, anything in the neighboring areas, somebody's trying to flee, find out what's going on in the area. They didn't do that.
To Justice Zara's point, they weren't going to change out of their uniforms or put their guns leave them in their car, right? You don't think that would be reasonable police activity,
No.
do you?
But the totality of the circumstances is that they have a showing of force, a showing of authority, all encompassed together for the totality of the circumstances, which shows.
Cases talk about a lot of different circumstances. They didn't draw their weapons on your client, did they?
No. When I watch the video, I see one officer's approach. One officer, he's got his arm like this, but it's on the other side of the car. I can only assume he's going in there with a ready position, like officers are trained to do.
Well, should he not do that? Should they approach the car not in a ready position?
Well, That's the thing. That show of force triggers the Fourth Amendment. And if this was a casual encounter, they shouldn't be in that ready position because that's a show of force.
Would it have been appropriate to run the plate?
It would have been appropriate to run the plate first, yes.
So is it unreasonable to say, we see a car where we wouldn't expect to see a vehicle at this time running, let's run the plate. Is it unreasonable to pull up partially behind the car to see the plate and run it from the car before you get out of your vehicle?
That would be a reasonable thing to do.
So isn't that what they did?
They didn't run the plate before they got out of the car. There's no evidence that they did that.
Counsel, so I have a question, and I may be getting, I think I'm viewing these as separate inquiries, right? What the lower courts determined is the question of whether or not your client was seized. What hasn't been determined, although I understand that the prosecution argued it a bit, but no court has decided whether or not, if there was a seizure, whether there was reasonable suspicion to support that seizure. So the question of whether it was reasonable, could they have come in and looked in the parking lot, was all of those things, that goes to the question of reasonable suspicion, which is not the question in front of us, correct? We are looking at, was the defendant seized, meaning under the totality of the circumstances, would a reasonable person feel free to leave?
Correct. And so the lower court made a determination that the seizure occurred before they start to engage with Mr. Duff. And so at that point in time, the Fourth Amendment was triggered and they had no reasonable suspicion to conduct that.
So, but the question of reasonable suspicion hasn't been determined by the lower courts yet, correct?
Correct.
Okay, so the question of, was it reasonable for them to see a car in the parking lot, a school parking lot at 10 a.m. or 10 p.m. on a Sunday night, that goes to reasonable suspicion. That doesn't go to the question of seizure.
Correct. And
Okay.
not to cut you off, I'm below my 5-minute mark for rebuttal.
Sure.
And so I'd like to reserve those, 4.5 minutes for that. Thank you.
Good morning, Madam Chief Justice, and may it please the court. Oakland County Assistant Prosecutor Joshua J. Miller on behalf of the people. The people respectfully ask this court to deny leave to appeal or affirm because the Court of Appeals correctly concluded that the deputies did not seize the defendant when they initially approached his car. Absent the use of physical force, a seizure occurs only if the police make a show of authority that would communicate to a reasonable person that they cannot leave or decline to interact, and the person submits to that show of authority. When the police park a patrol car near a parked car in the empty public parking lot of an elementary school in a way that provides for their safety and the motorists, illuminate it with a light because it's dark outside, and approach the car on foot, no seizure follows because those actions do not convey that interaction is required. More than a dozen states and at least 4 federal circuits recognize that these circumstances do not lead to a seizure, and the people could find no jurisdiction that holds otherwise, nor did the defense cite any. Moreover, inherent indicia of police authority, like wearing a uniform or a holstered sidearm, do not transform this type of encounter into a seizure, as the U.S. Supreme Court has held in cases like Drayton and Rodriguez. Overt displays of authority that can lead to a seizure, again, none of which occurred here, may include using sirens and emergency flashers, drawing weapons, giving orders, rushing up to a person on foot or to a car, or several officers surrounding a car on all sides. Like a complete blocking of a parked car, these acts may, and I stress may, convey to a reasonable person that interacting with the officer isn't optional. Again, though, this showing is only a necessary but not a sufficient prerequisite to finding that a seizure occurred because the individual still has to submit to the show of authority. In this case, it was the absence of any display of authority, a genuine question of whether the defendant was even aware. Good morning, Your Honor.
Look at things in a more kind of realistic kind of perspective. And I guess the question I'd pose to you is, here you have an encounter with a citizen and law enforcement. What is it that this citizen could have done differently in this situation? Like, in a practical way, the average citizen, you're approached by the police, you know, with all the things that we've heard, what is it that this individual should have done differently?
The individual, aside from not parking his car in a elementary school parking lot.
No, I'm talking about with the encounter.
With the encounter, I honestly, Your Honor, don't know what the citizen could have done differently, because we're not, the record seems to convey that he was not even aware that the police were there. He told the officer that he had pulled off because he was resting. Counsel conceded at the status conference in March 2020 that his client was sleeping in the car.
But would the average citizen feel as though they could leave?
If there is room for them to leave, that if they are not even aware that the police are there, certainly. In this particular circumstance, the car was not blocked. Counsel continues to emphasize that the car was blocked, that the car was blocked. The car was not blocked. The officer testified that he was parked in such a way that if he had backed straight out, Mr. Duff's car may have made contact with his patrol car. But if he backed his car out in a normal fashion, as a normal person and a normal driver would, he would have been able to pull out and pull away.
Do the lights matter at night? I understand, to Justice Zara's point, if it's dark out, of course they're using a light, but of course a light is very bright and can sort of make it difficult to do what you're saying they do. Does that matter?
The light does not make a difference, given the circumstances. They are not using the light for intimidation purposes. He testified they're using it for safety purposes. The danger that would be present from one or two officers approaching a parked car in a parking lot at night without illumination, I think is far more dangerous than them using a light to illuminate the situation, so that not only can they see what's happening in the parking lot and at the car, but that the motorist can see that these are not, I don't know, carjackers or complete strangers approaching him about to do something untoward.
Right, and I certainly understand that and take no issue with that. But at the same time, I'm sort of wondering if any bright light behind you at night creates almost like you're walled in. You know, you've got the police car in one angle and then maybe the light behind you. Again, just looking at the totality of the circumstances.
No, that's true, but the manner in which he would have had to back out, there was no light in that direction. The police car was parked to his left rear, and to pull out, all he would have had to do would be to cut his wheel to back out to the right. There was no patrol car, there was no officer, there was no light in that direction. So, yes, there may have been something in one direction, but again, you have to look at the totality of the circumstances. Now, if there had been a second patrol car coming from the other direction shining lights, I would not disagree that there was a display of authority that would tell a reasonable person they can't leave or decline to interact, again, assuming they're aware of the police presence and they then submit to it.
When we're evaluating the totality of the circumstances, are we looking at the subjective understanding of the defendant?
No, you're looking
Because
at,
we're looking at the totality of the circumstances and the objective conduct, right?
we're looking at how a reasonable person in the defendant's position would react, but we're looking at the totality of the circumstances, what the officers are doing to convey, if the officers are conveying an authority, an intent to seize.
So I guess I'm not understanding, maybe I'm just missing, what is the relevance of whether or not the defendant subjectively understood that the officers were there?
That goes to the ultimate question of the awareness argument is that a reasonable person has to be aware that the police are displaying authority before they can submit to that authority. There are cases in other states that I found, Colorado, Arizona, Florida, and I believe an unpublished case from Wisconsin, that convey, I want to make sure I get the quote right, that a reasonable person unaware of any police presence would have absolutely no reason to believe he was not free to leave. And so if we're looking at the totality of circumstances, we're looking at what a reasonable person believes. If a person is not aware that the police are there, it's a factor in the totality.
Okay, and what in this case, what record, part of the record establishes that despite the fact that the car was parked partially blocking him, despite the fact that there were two officers on the side, one of which had a flashlight shining in and the other had the cruiser light on it, what do you cite to suggest that he wasn't aware that the officers were there, or may not have been?
There was testimony that when the officer, as they were talking to him afterwards, they asked him what he was doing there, and he said he had pulled off because he was resting. And at the status conference in March 2020, counsel conceded, I believe it was page 5 of that transcript, that it's either page 4 or page 5, that his client was asleep in the car. So if it is true that the defendant was resting or asleep, then
You're inferring that he wasn't aware of that based on a statement that he was asleep at some point.
yes, we have to rely on the record that we have because the defendant.
But you're
didn't
relying on an
testify.
inference from a fact
On an
in the
inference
record.
from the
Sure.
record, yes.
So I just want to confirm the same question I asked of Brother Counsel. You agree that the only question we are deciding, and the only question so far yet decided, not that it doesn't need to be decided at some point, but the only question we're deciding is whether or not there was a seizure, not whether or not that seizure was justified by reasonable suspicion.
That's correct, Your
Okay.
Honor. I would-
If we can go back to the location of the car,
Yes.
I think, and I may be misstating what you said. I think you said that you can't find any other cases that are comparable here with this type of blocking of the vehicle. But there's the case from the Sixth Circuit, Williams, which I think has very indistinguishable facts from this. Although the car was blocked on all sides, I believe that where the police vehicle was, the defendant could have driven around that vehicle. But in the Williams decision, they said that a defendant would not feel free to leave. Can you match that with what we have before us?
I want to clarify first, Your Honor. The cases that we found, that we cited in our brief, are more than a dozen states and federal circuits holding that circumstances like this, the so-called partial blocking and use of a spotlight are not tantamount to leading to a seizure. So that I just wanted to place that on the record. But cases, like I did not find any case, nor did the author of the supplemental brief, who is no longer with my office, find cases that say that just a partial blocking is a show of authority sufficient to lead to a seizure.
Even if there's other factors on top of the partial blockage.
Well, if it's only a partial blockage, then you do have to look to other factors. But in those specific cases that were cited in our brief, it was the factors of a partial block and the use of a light of some sort, as well as approaching on foot. So no emergency lights, no sirens, they're not rushing up to the car, they're not giving commands. But the more of those things you add on, so if say in this case, the officers had exited their car and immediately said, "Don't go anywhere, we're coming up to your window," then you're adding more factors on. But the absence of those factors weighs against a finding that there was a show of authority, and then submission to that show of authority.
Does darkness matter at all? The fact that it's late at night?
It matters insofar as you're weighing the practicality of using a light. It does also matter because it gives the officers reasons for not only parking in the way they did, but using the light for their safety. Because I do not see how else the officers in this particular instance, given the circumstances, given the time of day or time of night, could have parked otherwise. If they park farther away, they are giving themselves more distance that they have to cover if the person in the car, it turns out, is hostile. They can't pull up directly next to the car because then that person, if that person has a weapon and is startled, has a line of sight directly into their patrol car. And so parking in the way that they did protects their safety as well as the motorists. And same thing, if they had pulled in directly behind him, then they risk somebody being startled, slamming the car into reverse, and backing into their patrol car. So I don't think that there is, given the circumstances, there's no other way that the officers could have approached this that would have comported with their safety, the motorist's safety.
Can we go back to, thank you for your clarification. Can we go back to the Sixth Circuit decision in Williams? And is the case before us distinguishable from that?
I'm sorry, I don't recall the circumstances in Williams off the top of my head.
So my understanding in that case is that the defendant's vehicle was parked, and there were cars on either side, and the location of the police vehicle was parked in such a way that it was in front of the defendant's vehicle, but that the defendant could have driven around it, similar to the circumstances that you've presented before us, where at a certain angle, defendant could have moved his vehicle. And I think the rest of it was very similar. You used a spotlight, approached the vehicle, and the Sixth Circuit said that a person would not have felt free to leave.
I think part of that goes to specifically where the police cruiser parked. If they were parked in front, it weighs differently than if they're parked in back, because again, you're looking at the surrounding circumstances. A person seeing a police car parked at an angle, shining the spotlight presumably directly into the windshield rather than just illuminating the area generally, conveys a different message than parking behind, near, at an angle, but just using the spotlight for general illumination purposes.
As I shared with your opposing counsel, I've got some concerns about People v. Anthony. Given the current state of Fourth Amendment law, do you think People v. Anthony went a little too far?
Actually, Your Honor, I don't think Anthony went too far, because Anthony is specifically discussing the factor of the patrol car's position alone. And I analogize it to the language used by the U.S. Supreme Court in California versus Hadari D., where they said they were talking about the only if, a person is only seized if they would not feel free to leave or otherwise engage in encounter. And they said the words only if are not equivalent to whenever. So I read Anthony to being that the Court of Appeals is not saying that a person is seized whenever the police completely block the car, but to say that it is a sufficient prerequisite on its own, assuming that the person is aware and then submits to that show of authority, to tip the scales in favor of a seizure.
So essentially you're telling me I'm reading too much into it.
It may be essentially
Okay.
reading it too much into it,
Yeah,
Your Honor.
that's fine. Thank you.
Unless there are any final questions, I see I've used my time. Thank you.
Thank you. And just to note commonplace on those, what could Mr. Duff has done differently? If he were to try to back out, you got two officers ready to go, not knowing what's going on, and we've seen this all too many times. The officers are gonna start shooting. They're gonna stop the guy. The officer's own testimony was he was gonna stop the guy and put the lights on because he was gonna do his investigation. It shows the intent of the officers that this was meant to be a seizure, that this guy was not meant to leave. Shining the light in somebody. Now, Mr. Duff, to back out, he'd have to turn his wheel all the way to the right, either look over his right shoulder or his back shoulder to see where this patrol car is, and that's where the spotlight was. And you can't pinpoint where this car is so you don't hit it with a spotlight there. So the spotlight alone was a seizure because it wasn't a reasonable person would not look into a spotlight, try to back up around a police car, not knowing how far or how close it was.
Do you agree it's a totality of the circumstances that we're looking at?
Yes, I do.
So if that's the standard, is it fair to say a show of restraint of authority also needs to be considered? What I mean by that is they had guns, but they were holstered, right? They had overhead lights, another show of authority, but they didn't use them. They could have completely blocked the car, but they didn't. These are things showing a restraint of authority, and in a totality of circumstances analysis, don't those factors come into play?
They do, But the test is what would a reasonable person do? Would they feel free to leave? So they didn't use the overhead lights, but even without that, there's a car behind you. Is it reasonable for me to want to leave right now? Everybody's not lawyers and scholars and judges and familiar with the case law and the laws of the state and of the country. And so you take a reasonable person that sees a cop car behind you and spotlights here, flashlights here, and two cops coming up to you, and you don't know what's going on. That show authority shows that there is a reasonable person would not feel free to leave. Therefore, there was a seizure.
So if the police car had pulled in the spot 2 down from defendant's car, and then both police officers got out and then with their flashlights walked up because it was dark, would that have been a seizure?
It could have been a seizure based on how they interacted. And the problem with this case is the dash camera starts a minute and 15 seconds. The audio starts a minute and 15 seconds in, well after the officers get out of the car. In your scenario, Judge,
Keep everything else the same. Just move the location of the police vehicle.
There would still be a seizure, in my opinion, based on the fact that the spotlight stopped him and there was an officer on each side. And for him to put the car in reverse and try to back out with an officer on each side that close, the officer's going to back up. They're going to say, hey, man, what's going on? He has a right not to talk to him or do
So
anything.
getting back to the question I asked you before you took your break, I asked you what should these officers have done? And so I just want to make sure I understand your position is if the police see something they think is suspicious at night, they should park a distance from the car in darkness, not use lights, and only one officer should approach the car. Is that your position as to correct police conduct under the Fourth Amendment in these circumstances?
It's like it's a trick question, and I want to do my best to answer it.
I'm not trying to trick you. Well, here's what I'm thinking about. The police are trained on the law, what they're supposed to do. The police here, one might argue, your opposing counsel might argue, followed their training to the T. The training tells them don't park directly behind the car, you have to park off at an angle. Don't draw your weapons. Don't raise your voice, right? All these different things. Don't put your overhead lights on. That's how they're trained. So after this case, if this court were to find that this is a violation, I'm wondering what it is we tell police officers going forward. What will the training tell them? In these circumstances, when you suspect somebody might be involved in illegal activity, which in fact was true in this case, or at least appears to have been, they've been on to something, because your evidence, at this point at least, I guess it hasn't been fully adjudicated, but the evidence is that your client was about 4 times the legal limit with alcohol. So if they suspect there's criminal activity, should their training manual say, if that activity occurs at night, you are to ignore that activity and go on your way? Is that what the manual should say, or should it say something else?
Judge, what I think the manual should say is that you don't infringe on, citizens' constitutional rights. And the fact that you want to conduct an investigation, conduct your investigation. But you can't show signs of authority. You can't approach the vehicle. They want to approach it as a casual encounter. And in this case here, that's what their argument switched to that after the preliminary exam, and we filed our motions in the circuit court. And
Counsel, can I just clarify once? If we find that there was a seizure, that is not the same as us finding that this was violative of the Fourth Amendment, correct? Because it's only violative of the Fourth Amendment if there wasn't reasonable suspicion to support the seizure. So a decision from this court saying there's a seizure, now go to the next step and figure out whether or not everything the officers did was reasonable, everything was based on a reasonable suspicion of potential criminal activity. We're not deciding that part, right? We're deciding whether or not there was a seizure.
correct.
Which doesn't decide the final Fourth Amendment question. Because you can have a seizure consistent with the Fourth Amendment so long as it's supported by reasonable suspicion.
Correct. But what I do believe the trial court and the evidentiary hearings record supports that they had no reasonable suspicion to conduct the seizure as it's mattered, because a lone car parked by itself in the middle of the night is not enough. And these officers may have had a hunch.
Obviously, the seizure question is the only question in this case. That's why
Correct.
it's been presented to us. I suppose it could go back, and some arguments could be made, maybe some good ones, that there's reason to suspect illegal activity from the car running in the parking lot at night at the elementary school. That's a closer question. We're here to talk about what range, what latitude there is for officers to engage with members of the public even before there may be reasonable suspicion. And so that's why if we move the seizure up all the way to the beginning, it really limits the police activity, ability to investigate crime. Do you agree?
I do agree, and I also agree that the case law supported throughout the state of Michigan and in the United States is that it's a reasonable person, would they feel free to leave or disengage? And in this case here, with the totality of the circumstances, Mr. Duff was not.
I think it's important to keep in mind that everyone recognizes there are some normal coercive pressures or people feel pressured to respond to police officers, and the case law deals with this. The police may rely on the moral and instinctive pressures of citizens to cooperate, and that a confrontation is a seizure only if the officer adds to those inherent pressures. That's why we've been trying to focus on your argument, for example, that the spotlight adds to the inherent pressures, because there's a baseline of pressure that is okay and that's acceptable in the case law. Would you agree?
I do agree, Judge.
And to follow up with Justice Viviano's questions, would it have made a difference if it was daytime? Car parked on the angle, no spotlight needed, obviously. Would that have made a difference here? Do the police have to act differently at the day and night?
I believe if this occurred in broad daylight without the use of the spotlight, the way they parked their vehicle and two officers approaching, that it would still be the same, that there was a seizure even with or without the spotlight. The spotlight helps my position that he wasn't free to leave, and that was a show of authority, which a reasonable person would not feel free to leave. In addition to that, if this was in the daytime, it would dispel the whole reason why they even pulled in to check this out, because in the daytime, it'd be normal for someone to maybe park in a parking lot without any, gates or signs of that, and they would not want it to go investigate a crime or anything in the daytime. And so,
Would it be fair to say that when we're looking at the totality of the circumstances and as you're going through each action by law enforcement, that you check the box for each one, individually, that each one of them that qualifies as a seizure?
yes.
Okay.
Yes, I do. And to take that one step further, when you add them all up, the totality of circumstances shows that this was a seizure before they even, up until the point that, their voice ended with the last question of, insurance, registration, license, up until that point before there's any response from Mr. Duff, that seizure occurred prior to that.
Thank you. Any other questions? The case will be submitted, and the court will stand in recess until 10:50 when we reconvene in the Hall of Justice for the remainder of our October call. Thank you.
Thank you very much, everybody.